He didn't think I'd show up to that meeting. That was his first mistake. I was 31, working as a pediatric occupational therapist at a clinic in Phoenix, and I had been seeing my boyfriend's father's attorney for exactly 12 minutes before I understood that none of this had been arranged for my benefit. Let me back up. His name was Colton. We'd been together for about 14 months when I found out I was pregnant. He was 39, a real estate developer who split his time between Scottsdale and Denver. The kind of man who wore expensive watches without ever checking the time because he already knew people would wait for him. We weren't serious in the way that involves conversations about the future. We were comfortable. I thought comfortable was enough. I was wrong about that too. When I told him, he went very still. Not shocked still. Calculating still. There's a difference, and I know it now even if I didn't name it then. Okay, he said. We'll figure something out. I should have asked what he meant by we. I didn't. 3 days later, I got a call from a number I didn't recognize. The man on the other end introduced himself as someone who worked for Colton's father. He said his name twice, slowly, the way people do when they want you to understand that the name itself is supposed to mean something to you. It didn't mean anything to me, but I looked it up after we hung up, and I understood. Colton's father was a man named Harlan. He had made his money in commercial construction starting in the late 80s, the kind of generational Arizona money that gets its name on buildings and hospital wings. He had 4 attorneys on retainer, 2 of whom specialized in family law. I only learned that last part later, but I'm getting ahead of myself again. The man on the phone asked if I would be willing to meet. He said it was informal. He said it was just to talk. I said yes, because I was still operating under the assumption that people who want to talk actually want to talk. The office was in North Scottsdale, the part of the city that smells like new carpet and filtered air. I wore a blazer over a dress because I was nervous, and I wanted to look like someone who couldn't be dismissed easily. A woman with a clipboard walked me to a conference room and offered me water. I took it. My hands were steady. I was proud of that. The man who came in was not what I expected. He was soft-spoken. He had reading glasses on a chain around his neck like a professor. He set a folder on the table and didn't open it right away. Colton's father has asked me to reach out, he said, because the family wants to handle this sensitively. I said I appreciated that. He nodded. He opened the folder. The number at the top of the first page was $400,000. I looked at it for a long time. I looked at it the way you look at something that doesn't make immediate sense, the way you look at a word you've spelled 100 times that suddenly seems wrong. That would cover medical expenses, he said, relocation costs if needed, and what does it cover, I said? He paused. What does the $400,000 cover, specifically? I said. What am I agreeing to in exchange for it? He cleared his throat. He had clearly expected a different kind of reaction. He explained carefully that the family would prefer a private resolution, that Colton was at a stage in his career where certain complications could affect ongoing business relationships, that this arrangement was not unusual. I thought about the word complications. I want to understand what you're asking me to do, I said. He said the family was prepared to support me financially in exchange for a signed agreement that I would not pursue paternity or child support through the courts. I nodded slowly. Then I folded the paper and put it in my purse. He looked alarmed. I told him I needed time to think. He said of course. I thanked him for the water and I walked out to the parking lot and I sat in my car for a long time. Then I called my older sister. My sister has always been the person I call when something happens that I need to say out loud before I can understand it. She lives in Tucson, teaches high school English, and has a way of being quiet on the phone that makes you feel like you're being heard through a wall of very calm glass. I told her everything. She was quiet for a moment. Did you sign anything? She asked. No, I said. Good, she said. Don't sign anything. Go home. I'll call you back. She called me back 40 minutes later with the name of a family law attorney in Phoenix, a woman who had spent 15 years handling high-asset cases. My sister had found her through a friend of a friend who'd gone through a messy divorce with a wealthy husband. I called the attorney's office the next morning. Her name was Elise. Firm, no nonsense, the kind of person who has clearly stopped tolerating things she doesn't have time for. She asked me to come in Thursday. I went Thursday. I brought the paper I had taken from the conference room. She read it without changing her expression. They came at you early, she said. Is that unusual? It means they have assets they're very interested in protecting. She set the paper down. Tell me about the father. What does he do? I told her about Colton. About the real estate development, about the father's construction company, the buildings with the family name on them. She wrote things down. She asked about our relationship. She asked if there were text messages. I said yes. She asked if I still had them. I said yes. Good, she said. Don't delete anything. I asked her what my options were. She leaned back in her chair and told me about paternity establishment in Arizona. She told me that prenatal paternity testing, a non-invasive process done through a blood draw, was legally admissible. She told me that once paternity was established, child support would be calculated based on income, and that in high-income cases, the court does not cap support the way many people assume. She said it was based on the child's actual needs relative to the parents' incomes. She paused here to let that sink in. The number they offered you, she said, is structured as a one-time payment. Child support is ongoing, adjusted for cost of living, and reviewable if circumstances change. I did the math slowly. Elise filed the petition to establish paternity the following Tuesday. I didn't tell Colton in advance. Elise had advised me not to. A process server delivered the paperwork to his office on a Wednesday morning, during what I later found out was a meeting with investors. I felt a complicated emotion about this that I will not fully describe, but it was not guilt. Colton called me that evening. He was not calm. He said I had ambushed him. I said I had been ambushed first, in a conference room I didn't know I was walking into. He said that wasn't the same thing. I said I disagreed. He said his father was furious. I said I understood. You don't understand what you're doing, he said. I understand exactly what I'm doing, I said. I'm establishing the legal rights of my child. He hung up. 3 days later, a different attorney called me, one representing Colton directly, not his father's firm. He was smoother. He suggested that perhaps there had been a miscommunication. He suggested that Colton would be open to revisiting the financial arrangement if I was willing to withdraw the petition. He used the word revisiting 3 times in one conversation, which told me they were uncomfortable. I told him my attorney would handle all further communication. I won't pretend the next few months were easy. The prenatal DNA test was done at 10 weeks. It was a simple blood draw. The lab processed it in about 2 weeks. The results were exactly what everyone already knew they would be. Meanwhile, Colton's legal team filed a motion arguing that prenatal paternity testing was premature and that the petition should be stayed until after the birth. Elise filed a response. The judge denied the motion. There is a particular silence that happens when you're sitting in a courthouse hallway waiting for something. I had brought a book I didn't read. I had brought water I didn't drink. I sat there in the same kind of blazer I'd worn to that first conference room meeting, and I thought about the fact that I was 31 years old and 3 months pregnant, and I had walked voluntarily into one of the most complicated situations of my life. And somehow I felt more settled than I had in months. Elise came and sat next to me. "You doing okay?" she asked. "Yeah," I said. "I think I'm okay." She nodded. She didn't say anything else. I appreciated that. The hearing itself was unremarkable in the way legal proceedings often are. A lot of careful language, a lot of documents being referenced, a lot of waiting. Colton was there with 2 attorneys. He didn't look at me for most of it. His father was not present, but I heard later he'd been in the building. One of the paralegals at Elise's firm mentioned it. I don't know if that's true. It might have just been courthouse gossip. The paternity was established without contest. They had tried procedural arguments, but once the DNA results were filed, there wasn't much to contest. After the hearing, Colton's primary attorney approached Elise. I watched them talk in the hallway. I stood a few feet away and looked at the scuff marks on the floor tiles. When Elise came back to me, her face was composed, but I'd gotten good at reading her by then. "They want to settle on support," she said. "What are they proposing?" she told me. It was significantly higher than the original $400,000, but still structured as a lump sum. A clean, private resolution. No court order. No ongoing oversight. I said no. I said I wanted a court-ordered child support arrangement based on verified income. I said I wanted it on record. I said I wanted it reviewable. Elise looked at me for a moment. "That means discovery," she said. "Financial disclosure." "I know," I said. She almost smiled. "Okay then. Financial discovery in a high-asset child support case means that Colton's Etzman's interests became subject to court review. His attorneys tried to limit the scope. Elise pushed back. The court sided with her on most of it. What came out in discovery was not scandalous. It was simply real. Colton earned considerably more than he had represented to me in casual conversation. Not unusual, I've come to understand, for people who are accustomed to talking about money in ways that make them seem more approachable. His ownership stake in several development projects, the distributions from his father's holding company, the rental income from 3 properties in the valley. It added up. The child support calculation in Arizona uses the income shares model, which considers both parents' incomes. My salary as an OT was not low, but the disparity was significant. The court calculated support based on the combined income and the projected needs of the child, including healthcare and childcare costs in a high cost of living area. The number was more than 3 times what their original settlement offer had implied on a monthly basis. Colton's attorneys requested a continuance. The judge granted them time to respond to the calculations. They came back with their own financial expert, who argued for adjustments to how certain income was categorized. Elise had our own CPA review the filings. There were 3 more hearings. I attended all of them. I learned how to read a financial disclosure form. I learned more about depreciation schedules and LLC distributions than I ever expected to know. My daughter was born in early October. I was in labor for 19 hours. My sister drove up from Tucson and stayed in the hospital room with me the whole time. My mother flew in from Portland the next day. When the nurse put my daughter in my arms for the first time, I thought about a lot of things, and none of them had to do with Colton, or his father, or their attorneys, or the courthouse. I thought about how small she was. I thought about how small she was. I thought about her fingers. I thought about how I was going to teach her things. The final support order was entered when she was 6 weeks old. I was sitting at my kitchen table in my robe, nursing her, when Elise called. "It's done," she said. Judge signed. I said thank you. She said you're welcome. She said she would send me a copy of the order. I said okay. I stayed at that table for a while after we hung up. My daughter had fallen asleep. She made a small sound, something between a sigh and a breath, and I looked at her face and I felt something I still don't have a clean word for. Not triumph, not relief, exactly. Something more like arriving, like reaching a place I have been walking toward for a very long time without knowing the address. Colton pays support every month. It comes on the 1st. I don't have to chase it, it's automatic. Court ordered. Reviewable every 3 years, or if there's a material change in circumstances. He has exercised limited visitation so far. His attorney negotiated a modest initial schedule, and Colton has used about half of those visits. He shows up. He holds her carefully, like he's afraid of doing it wrong. I don't know what kind of father he'll become. That part of the story isn't written yet. His father, Harlan, the man with the buildings named after him, I haven't spoken to directly. He sent a letter through his attorney at some point in the fall, something that was framed as reaching out, as wanting things to be civil. Elise reviewed it and said there was nothing legally significant in it. I didn't respond. There are people who have asked me why I didn't just take the original money. $400,000 is not nothing. I know that. I'm an occupational therapist. I rent a 2-bedroom apartment in Phoenix. $400,000 would have changed certain things for me materially, and I won't pretend otherwise. But here is what I knew that the man in the conference room didn't seem to understand. That money would have been a ceiling. It would have been the end of a thing. What I got instead is a floor, a number that is reassessed as she grows, that reflects what her father actually earns, that follows her through school and medical appointments and everything she needs that I didn't yet know to plan for. $400,000 disappears. A court order doesn't. I think about the woman who walked into that North Scottsdale office in the blazer, with the steady hands and the paper she folded and put in her purse. She didn't know exactly what she was doing yet, but she was paying attention. She was asking the right questions. She didn't sign anything she didn't understand. My daughter is 7 months old now. She has learned to sit up on her own, and when she does it, she looks extremely proud of herself. She has strong opinions about pureed sweet potato and no patience for slow mornings. She is, in ways I am only beginning to understand, entirely her own person. I am still her mother, learning alongside her, in the apartment in Phoenix with the 2nd bedroom that now has a small crib and a rocking chair and a string of soft lights along the wall. I don't think of myself as someone who won a legal battle. I think of myself as someone who understood that she had options, found people who could help her understand those options, and made decisions that she could live with, for herself, and for the small person who would one day be old enough to ask what happened. When that day comes, I want to be able to tell her the truth. All of it, that I was scared, and that I showed up anyway. That someone tried to write a number at the top of a page and hand it to me as though that were the end of the conversation. I had other plans for the conversation.